You ask someone for their lowest price. They tell you. You immediately say, "I'll take it." But then they refuse to sell. Can you force them to go through with it? In 1893, two men in Jamaica found themselves at the heart of this exact legal question in Harvey versus Facey, a case that drew a sharp line between a genuine offer and mere information. Background story. Mr. Harvey wanted to buy a property called Bumper Hole Pen in Jamaica, owned by Mr. Facey. Harvey sent a telegram to Facey. "Will you sell us Bumper Hole Pen? Telegraph lowest cash price." Facey replied with a telegram. "Lowest price for Bumper Hole Pen £900. Immediately, Harvey wired back. "We agree to buy at £900 asked by you." But Facey refused to sell. Harvey sued, claiming there was a binding contract. The court had to decide, was Facey's reply a legal offer or just a response to a request for information? Issue: did Facey's statement of the lowest price constitute a legal offer capable of acceptance, creating a binding contract when Harvey agreed? Rule: for a contract to exist, there must be a clear, definite offer. An invitation to treat or a mere supply of information is not an offer application. The court held that Harvey's first telegram contained two questions. One about willingness to sell, and one about price. Facey's reply addressed only the second question, the price, without expressing willingness to sell. This was not an offer, but a response to a request for information. Since there was no offer, Harvey's acceptance was meaningless in law. There was nothing to accept. Conclusion: the Privy Council ruled there was no binding contract. Facey's statement of the lowest price was simply an invitation to negotiate, not an offer. The Harvey versus Facey decision stands as a cautionary tale in contract negotiations. A price quote alone doesn't bind the seller. Without a clear offer, there can be no acceptance and no contract, whether in 1893 or today. Knowing the difference between a definite offer and an invitation to treat can mean the difference between closing a deal and walking away empty-handed. If you learned something new about offers and invitations to treat, hit the like button, subscribe for more contract law stories, and comment which case you want next. Your engagement keeps this channel alive and growing.